Hello, my name is Nicholas Meyer, and I'm an attorney with the Farm Worker Unit of Pine Tree Legal Assistance in Maine. This presentation discusses some of the rights of H-2A workers and workers who work with H-2A workers. Let's start with the simple question, what is an H-2A worker? Under U.S. immigration law, workers from another country may be admitted temporarily to the United States to perform agricultural labor if U.S. workers cannot be found to perform the job. Why are workers called H-2 or H-2A? If these workers are admitted to the U.S. for temporary agricultural employment, they are called H-2A workers. The term H-2A refers to the section of the immigration law that allows these workers to work in the U.S. They may only be admitted for temporary agricultural employment. By the way, workers admitted to short-term, non-agricultural, unskilled jobs are known as H-2B workers. Laws governing the employment of both types of workers are similar. This presentation focuses on H-2A workers. Do employers need special permission to hire foreign workers? In order to hire workers from other countries, growers must certify to the U.S. government that they are unable to find sufficient U.S. workers to do a particular job. This could be work harvesting apples or cultivating vegetables, for example. If there are not enough U.S. workers, growers are then permitted to hire foreign workers. How are the workers hired? Growers send out offers of work. These offers are called clearance orders. Clearance orders are job offers describing the terms and conditions of the job. These clearance orders detail the type of work to be performed and the terms of employment. A clearance order sounds like a kind of a contract. It is. This is an important document. It is the contract of employment between workers and the grower. Usually it is about 8 pages long and quite detailed. Workers should keep a copy of the clearance order with other important documents. There are many things in the contract the grower is required to provide each worker. Let's discuss this in greater detail. So what are the terms of the contract? First, under the terms of the clearance order, the grower must agree to pay a certain wage established by the federal government. This is known as the Adverse Effect Wage Rate, or AEWR. The AEWR in New England states and New York State in 2020 is $14.29 per hour. This is the minimum wage rate you can be paid in these states as an H-2A agricultural worker. It also applies to U.S. workers who work with H-2A workers. This wage rate applies even if you are paid on a piece rate basis, like a certain amount for every bushel or bin you pick. Even when you are paid by the piece, you must average at least $14.29 for every hour worked. It can be confusing figuring out hours that should be credited as work time. Let's first look at work time you should be paid for. Time that you should be paid for includes waiting time. Some of the time that you spend waiting at the work site is time that you should be paid for. Some examples are waiting for your work assignment, waiting for fields to dry, or waiting for ladders, bins, or other equipment to arrive. Travel time. After your workday begins, the time you spend traveling from one field to another is work time, and that you should be paid for. Breaks. A short morning, afternoon, or meal break under 20 minutes counts as work time. On the other hand, time that you do not have to be paid for includes lunch breaks that are 30 minutes or longer when you are allowed to completely stop working, and usually time spent traveling between a labor camp and the work site before work and after work. Use these guidelines to keep a daily record of your work hours, and contact us if you have any questions about your work time. Does a clearance order provide anything for U.S. workers? Yes, it should be noted the clearance order provides rights to U.S. workers. U.S. workers who work with H-2A workers have rights to the same pay rates. This wage rate, the AEWR, is generally much more than the usual minimum wage for agriculture. U.S. workers working with H-2A workers also have rights to other benefits provided to H-2A workers. In fact, the employer is prohibited by law from offering better wages and working conditions to foreign workers than it offers to U.S. workers. What are some examples of this? For example, H-2A workers are entitled to be reimbursed for travel expenses from their home base to the place of work. So too U.S. workers who have to travel to get to the job. Travel is reimbursed if the worker completes 50% of the contracted period. Travel expenses are reimbursed from the workplace back home if the worker completes the contract period. The employer also is required to provide transportation between living quarters, the labor camp, and the work site, free of charge. How about housing expenses? Housing must be provided free of charge to both H-2A workers and U.S. workers. Further, all provided housing must meet specific standards. For example, housing must be structurally sound, in good repair, in a sanitary condition, and must provide protection from the elements. Employers may not charge deposits for bedding or similar items. Who pays for meal expenses? As for meals, the grower must provide each worker with 3 meals per day or furnish free kitchen facilities to workers so they can prepare their own meals. Where the employer provides the meals, the clearance order must clearly state any charge for meals. But if the season is shorter than promised? The grower guarantees employment for at least 3/4 of the workdays of the total contract period in the clearance order. This means that, except for certain exceptions, the H-2A worker must be paid for at least 3/4 of the days in the contract. This is known as a 3/4 guarantee. There are times when the guarantee does not apply. Your boss will not owe you money if you are fired for a good reason, if you quit, if the contract is cut short because of a natural disaster, or if you are unable to finish the contract because you got hurt. But if you are sent home early or there is no work for you for some other reason, the 3/4 guarantee may protect you. If you want us to check for whether you received what was owed, please save all your pay receipts and call us at the end of the season. Is the grower required by law to hire U.S. workers? As part of its agreement with the U.S. government, the grower is obligated to hire qualified U.S. workers who applied during the first 50% of the contract period. As mentioned, this offer of employment must include housing and other benefits offered to H-2A workers.